Hi guys, I'm Gerald Postrero from BS Criminology 4C, and for today's video we're gonna talk about a motion to quash. What is motion to quash? A motion to quash is a formal request by the accused for the court to dismiss or quash the criminal complaint or information on grounds specified by law. So it is filed before the accused to enter a plea. Once granted, it prevents the case from proceeding to trial unless the court gives the prosecution an opportunity to cure the defect. So meaning, it's not about being innocent or guilty, it's about whether the charge is legally sufficient and proper. So according to Section 1, Rule 117, a motion to quash must be made before entering a plea. If you don't file it before the plea, you are generally deemed to have waived most of the grounds. However, there are a few exemptions. First, that the facts do not constitute an offense. Second, lack of jurisdiction over the offense charge. Third, extinction of criminal actions or liability, for example, double jeopardy. And now, let's talk about the grounds for a motion to quash. Under the Section 3 of Rule 117, the accused may move to quash the complaint or information on any of the following grounds. First, that the facts charged do not constitute an offense, meaning if the allegation in the complaint or information, even if hypothetically admitted, do not make out a criminal offense. Number 2, that the court trying the case has no jurisdiction over the offense charge, meaning the offense is not within the trial court's subject matter jurisdiction. Number 3, that the court trying the case has no jurisdiction over the person of the accused, meaning the court has not legally acquired control over the accused, usually invalid arrest or accused has not voluntarily submitted. Number 4, that the officer who filed the information has no authority to do so, meaning the prosecutor or officer who signed and filed the charge was not legally authorized. For example, the information is filed without the approval of the chief prosecutor. Number 5, that it does not conform substantially to prescribed form, meaning the information is defective in form. For example, it doesn't name the accused or state the essential elements of the crime clearly. Number 6, that more than one offense is charged except when a single punishment for various offenses is prescribed by law, meaning the information charges two or more distinct crimes in a single document. And there is an exemption when a single party is prescribed by law for various offenses. Number 7, that the criminal action or liability has been extinguished, meaning the crime is no longer prosecutable. For example, prescription of the crime or the accused has been granted an amnesty or pardon. Number 8, that it contains averments which, if true, would constitute a legal excuse or justification, meaning the information itself, by its own words,